May it please Your Lordship, I beg to mention item number 11 and 12. Your Lordship, on joint request, I pray that this is a joint request, Your Lordship.
Joint request of
This
petitioner and private respondent. State is not asking for adjournment, Your Lordship.
What is this, madam?
That suspension, that abandonment of service, Your Lordship. That case, Your
To
Lordship.
school teachers.
Yes, Your Lordship.
Why are you not pursuing this matter? It's
personal difficulty, Your Lordship.
huh? Personal difficulty. Every time you see, there'll be personal difficulty here and there.
It's a joint request, Your Lordship, with the private respondents.
Who's appearing for a prize?
Appearing for private respondent, Your Lordship.
One prayer made by the petitioner as well as the private respondent seeking accommodation on grounds of personal difficulty. That is adjourned. This is after 1 week.
It will be 4 weeks, Your Lordship.
Why 4
4 weeks, Your Lordship.
It's a 2020 matter, Mr. Right?
Lordship.
The more we delay, the more it goes on. See, 2023, 24 matter, it's okay. We can still afford.
But then 2 weeks, Your Lordship.
2 weeks.
Obliged, Your Lordship.
Please ensure the next time it's taken up.
Yes, Lordship.
No adjournment.
Yes, Lordship. Your Lordship, similar prayer for item 13.
It's also 2021 matter.
This matter pertains to notional promotion, Your Lordship.
Petitioner has already retired.
Yes, Your Lordship. He's retired.
Yes.
No objection, Your Lordship.
On pre made by the petitioner, not objected to by state respondent. That is adjourned. This is after 2 weeks.
I reply to Your Lordship.
Supplementary list, item number 1.
Yes, Mr. Shulai, you
I made pieces, Your Lordship. Lordship, I have the instruction, Your Lordship. What happened, Your Lordship? If Lordship kindly come to the writ petition, if Lordship kindly come to page 27, Lordship kindly see clause 9 of that agreement.
yes.
It says like this, that the second party, that means the writ petitioner, may set up whenever necessary checkpoint cum station office on convenient area on approval from the first party, and the second party should strictly ensure that such checking should not on the national highway, state highway, PWD, rural roads, Your Lordship. Then Lordship kindly come to the extension, that is, Your Lordship, at page 20. Lordship kindly come to 6, clause 6.
Yes.
That wherever necessary checkpoint station cum office may be set up on convenient areas may be agreed upon, provided that such checking shall not be on the national highway, state highway, PWD road, Your Lordship. This checkpoint, Your Lordship, check it, Your Lordship, was set up by the writ petitioner, Your Lordship, on the national highway, Your Lordship. There was also a report from the Superintendent of Police SB, Your Lordship. Kindly have a look, Your Lordship. Just a minute.
Without showing, we will replace.
Lordship, kindly.
Give him a copy.
Lordship, may I take Your Lordship to the second paragraph? However,
Yes.
However, during inspection, it was found that the authorized agent placed their offices on both sides of the national highway at Maukhanu for checking of illegal trading by non-tribal commercial transport operators. The offices set up by the authorized agent located right on the roadside with the national hardly 10 meters from the highway Moreover, the signboard is erected 35 meters from the national highway. The staff of the authorized agent is found to be stopping all type of truck levying toll on the highway, Your Lordship. So apparently, Your Lordship, yes, there is a violation of the clause, Your Lordship, of the agreement as well as the renewal agreement, Your Lordship.
No, but you see, Mr. Shulai, you have pointed out all these things.
Lordship.
But a process has to be followed. A process has to be followed, and that process is, subject to challenge.
Lordship,
Perhaps the petitioner has come precisely for that.
Lordship, then another aspect of also, Your Lordship, this is the order issued under 160 of the BNSS, Your Lordship. Kindly have a look, Your Lordship. If the petitioner is aggrieved by that, Your Lordship, there is a remedy, Your Lordship, provided under 163. Lordship, kindly come to section 163.
163.
163, Your Lordship. Lordship, kindly come to subsection 5.
Yes.
Any magistrate may either on his own motion or on the application of any person aggrieved, Your Lordship. So, Your Lordship, the writ petitioner as well as the district council, Your Lordship, here they are the aggrieved party. Resign or alter any order made under this section by himself or any other magistrate subordinate to him or by his predecessor in office. Then, Lordship, kindly come to 7. When an application under subsection 5 or subsection 6 is received, the magistrate or the state government, as the case may be, shall afford to the applicant an early opportunity of appearing before him or it, either in person or by an advocate and showing cause against the order. And if the magistrate or the state government, as the case may be, reject the application wholly or in part, he shall record in writing the reason for doing so. So, Your Lordship, the writ petitioner is at liberty to approach the government, Your Lordship.
So the
Why, Your Lordship?
impugn order was passed under section 163.
Lordship, yes. Lordship, kindly come to the impugn order. Lordship, kindly come to page 54. Why am I making this submission, Your Lordship? I'll point out, Your Lordship. 154, Your Lordship, Annexure 6. May I read it, Your Lordship?
Yes.
Order under section 163 BNSS, whereas it has been brought to the notice of the undersigned that there is illegal construction of checkpoint at Maukhanu by the Khasil Autonomous District Council for shaking of trading by non-tribal traders. Whereas government of Meghalaya has taken a firm stand and adopted a zero tolerance policy toward the extent of any illegal collection of toll, checkade, or forcible collection from traffic plying along the national highway, state highway, and major district road of East Khasil district. Whereas installation of these illegal checkade and barrier for forcible collection obstruct the seamless traffic flow, causing inconvenience to road users and also hazardous in safety point of view and may attract road accident. Whereas as per the letter from the government of Meghalaya, number so and so, checkade, tollgate on national highway and major district road cannot operate without the requisite permission from the Ministry of Road Transport and Highway and the state government, Your Lordship. So, Your Lordship, there is a letter from the state government, Your Lordship. The state government has adopted a zero tolerance, Your Lordship, of this mushrooming of checkades, Your Lordship. So there is an order, Your Lordship, from the District Council Affair, Your Lordship. Since this is the order passed by the District Magistrate, Your Lordship, the writ petitioner as well as the District Council is at liberty to file an application before the authority, Your Lordship. The government or the District Magistrate will take a call, Your Lordship.
My Lord,
Then, Lordship,
may I place my case?
Then another contention, Your Lordship, they have relied, writ petitioner have relied in the judgment passed by the this honorable court, Your Lordship, that is in Mayantis Maulot, Your Lordship. That is at page 29. Lordship, kindly come to page 29. This question whether the District Council, Your Lordship, has the authority to set up, Your Lordship, that has been left open. Your Lordship, I am taking Your Lordship to page 48. Lordship, page 48, Your Lordship, in the present matter.
Yes.
May I read, Your Lordship? In the present matter, all the aforesaid aspects have only been indicated with reference to the submission of the landed senior lordship. During that time, I was the counsel appearing for the state. However, it does not appear that such an appointment or agent for identifying and detecting the trading by non-tribal commercial transport was ever questioned by any individual or by the state government. Lordship, kindly note, your lordship, as being unauthorized and beyond the power available under paragraph 10 of the schedule. The power and authority with the council to control or interfere with the business of non-tribal commercial transport operator within its area being not the direct question involved in the present matter, that means in that Mayan Tesmo. It is left at that only, with the observation that such a question, when raised in the appropriate proceeding, may be considered on its own merit. Suffice to observe, for the present purpose, that the council would be able to exercise its power in conformity with law, and obviously the agent cannot carry out any such work which is not permitted by law. So, lordship, that liberty is given by this judgment, your lordship. The state now can question the authority, the source of power of the district council to check this checkpoint, your lordship. Because as I have submitted, your lordship, there is a national highway. For that, your lordship, they require a prior permission from the competent authority of the National Highway Authority of India. They just cannot set up like that, your lordship. Because that's why, your lordship, that's the district council is fully aware of this legal provision, your lordship. That is why they have inserted that stipulation, your lordship, that you should obtain the permission from the National Highway Authority of India, also the PWD, that is the competent authority of the government, your lordship. In my humble and respectful submission, your lordship, no interim order is called for, your lordship. Will file our affidavit, your lordship. The matter may be heard on merit, your lordship.
May I please make case, my lord. My lord, purported the issue, the impugned order has been issued under 163. Now I'll take your lordship to 163. My friend has directly jumped to 163.5, my lord, without reading 163.1. My lord, kindly 163.1, my lord. It says, my lord, power to issue order in urgent cases of nuisance or apprehended danger. Now, what is nuisance and what is apprehended danger is subsequently elaborated, my lord. It says, in cases where in the opinion of a district magistrate, a subdivisional magistrate, or any other executive magistrate, specially empowered by the state government in this behalf, there is sufficient ground for proceeding under this section, and immediate prevention or speedy remedy is desirable. Such magistrate may, by a written order stating the material facts of the case, and served in the manner provided by section 153. Now, we do not know where is the service under 153. Direct any person to abstain from a certain act or take certain order with respect to certain property in his possession or under his management, if such magistrate considers that such direction is likely to prevent or tends to prevent obstruction, annoyance, or injury to any person lawfully employed. Then, comma, my lord. So, my lord, the first requirement is that there must be a tendency to prevent, obstruct, annoy, or injure any person lawfully employed. That's one, my lord. Or danger to human life. Second, my lord. Third is health or safety or a disturbance of the public tranquility or a riot or an affray. My lord, we are all aware about 144. This is 144, my lord. When a 144 can be invoked, my lord. Now, what the impugned order says, my lord. My friend has read the impugned order, my lord. Impugned order says that state government has zero tolerance for construction of toll gate over the highways. Normally, they cannot at the same breath say that this is because of zero tolerance about a toll gate, or it is under 144 or 163 now. They cannot mix up the issues, my lord, like this. But the impugned order is page 54, what it says, my lord. Second paragraph, whereas the government of Meghalaya has taken a firm stand and adopted a zero tolerance policy towards the existence of an illegal collection of toll, check gate, or forcible collection from traffic plying along the national highway, state highway, or major district roads of East Khasi Hills. Whereas installation of these check gates and barriers of forcible collection, obstruction of seamless traffic flow, causing inconvenience to road users and also hazardous to safety point of view and may attract road accidents, whereas as per letter number government of Meghalaya so and so, gates on national highways or major district cannot operate without the requisite permission from Ministry of Road Transport and Highways and the state government. My lord, whether something can be constructed on national highway or not, there is an act to that effect, my lord. And your lordship, I'll place your order passed by your lordship. Same objections were raised in earlier occasion, my lord. That was with regard to Jaintia District Council.
That I'll point out also. Your lordship.
Let me complete. Let me complete. Section 29, my lord.
Traffic.
Yes.
But they refer to this section, my lord. (28) and 29, my lord. I'll read both. Right to access. (28) says, my lord, right to access. No person shall have the right to access to a highway either through any vehicle or on foot by a group of 5 or more persons except permitted by the highway administration either generally or specifically in the matter specified in section 29. The access to a highway under subsection 1 shall be subject to the guidelines and instructions issued by the central government from time to time. The highway administration may, by notification in the official gazette, declare highways or any portion thereof to be limited for access in the manner as specified in such notification. May also impose any restriction or control on such access to, from, or across such highway as specified in that notification. 29, my lord. Procedure for permission to access to highway. The general permission under subsection 1 of section 28 shall be given by issuing notification in the official gazette for such purpose, and specific permission under subsection shall be given in the manner specified herein under this section. Any person desirous of obtaining specific permission referred to in subsection 1 may make an application to the prescribed form to the highway administration, specifying therein the means of access to which such permission relates, and shall also be accompanied with such fee or as may be prescribed, and so on, so on. So, my lord, it is for national. Is there any complaint from National Highway, my lord? That is the first question they have to answer, my lord. Who are they to take up the jurisdiction of National Highways Authority, my lord? With the state government? Which law empowers the state government to take action for violation of any right of National Highway, my lord? My lord, these are all, and the impugned order says, my lord, it is because of zero tolerance of. Now, my lord, I'll take your lordship to the. My friend has referred to the earlier Minority Small Lot order, my lord. Picking up one paragraph will not help, my lord. You have to read the entire judgment in context, my lord. Page 46, my lord.
Yes.
Page 46. This judgment is a very long judgment, but I'll just read the relevant portion. At page 46, my lord, after the quoted part, my lord, in clause 10 of the regulation of 1954, the Executive Committee of the Council has been empowered to make the rules for carrying out the purposes of regulation, and accordingly, the rules of 1959 have been made by the Executive Committee of the Council. Therein, the provisions have been made for different nature trade services as specified in first schedule, and in part F thereof, transport service has also been included. The court is clearly of the view that when the council has the power to make regulation for control of trading by the non-tribals within the jurisdiction as per paragraph 10 of the 6th schedule to the constitution, the power to appoint an officer, staff, and agent or to achieve the objects of regulation is inherent and innate therein. It remains right that the power to do something essential for the proper and effectual performance of work which the statute has in contemplation may be implied, so and so, and that an express grant of statutory powers carried with it, by necessary implication, the authority to use all reasonable means to make such grant effective, right, so and so. Thus, looking to the nature and purport of the powers conferred by paragraph 10 of the 6th schedule, there is hardly any reason to take exception against engagement of an agent by the council to identify and check the legal trading by non-tribal traders. However, the concerned agent has also the principle that is KHDC shall have to remain within the confines of the power available in law and cannot exceed the same in any manner. So, my lord, this question has been finally decided by this Honorable Court. There has been no appeal against the order passed by the then Chief Justice, my lord. Now, so this settles the issue that District Council has the power to appoint an agent to check non-tribal traders, transport vehicles, my lord. Now, transport vehicles will definitely ply on the highway. They will not ply on on a football ground or somewhere, my lord. Now, secondly, my lord, the order itself says, my lord, the report which my friend placed, that it is hardly 10 meters. So that means it is 10 meters away from the national highway, my lord. And they are saying the signboard is also hardly 5 meters away from the national highway. So we have taken full care of that, my lord. Third aspect, my lord, my friend is referring to the agreement between district council and the agent, my lord. Now, if any right accrues under that agreement, it is for the district council to take action, my lord, not for the state government to take any action, my lord. So, my lord, how can the state assume power of National Highway Authority of India, of the district council, Khasi Hills Autonomous District Council, my lord? But these actions are, my lord, absolutely perverse actions of the state government, unlawful in law, my lord. And I'll place your lordship the earlier order passed by your lordship, my lord, that is starts from page 55. And that is still operative. The state is taking adjournment on the ground that a matter is pending before the division bench, my lord. But there is no reason, my lord, the same interim order should not be passed in case of KHDC, what has been passed in case of Jainti Hills District Council, my lord. On page 55, the order starts, my lord. My lord, in para 6 at page 57, same national highway traffic regulation. That time Advocate General appeared in the matter, my lord. He raised the same issue, my lord, at para 6 lordship says. However, as regard the reference to the respondent to the control of National Highways Land and Traffic Act, the learned senior counsel has submitted the section 38 XPs of the requirement of seeking permission from the highway administration before any construction is made on the national highway. However, the impugned orders were issued by the District Council Affairs Department of the state, which has no authority in this respect, and nowhere was it mentioned that any complaint has been received from the national highway in this regard. The issuance of the impugned order is therefore an act of malice in law, it was asserted. This was my submission recorded, my lord. Now, para 8, my lord, and this is not very long, my lord, this was in 2022. Again, while referring to NHR R9 of the affidavit, which is a copy of the minutes of the meeting held on 23/6/22 to discuss the issue with regard to establishment of toll gates by district councils and traditional institutions, which meeting was chaired by the Honorable Chief Minister, the learned senior counsel has submitted that in the said minutes, it was recorded that the chairman has assured that the government is not interfering in the collection of tax and fees by the district council and other traditional institutions, but not on national highways or state highways or major PWD roads, which is exactly what the petitioner has maintained when it was asserted that the concerned check gates was not situated on the national highway. Now here also it is established, but they admit, my lord, it is 10 meters away from the national highway. Now, my lord, my lord, in the earlier hearing, they referred to another decision of Sadangu El Dakar. Now, it turned out that was with regard to royalty gate, my lord. So, and this honorable court distinguished that royalty gate is altogether different matter because royalty collection is state government's power. So, district council or any agent cannot erect a parallel gate to the DMR check gate for collection of royalty, my lord. If I may refer to para 27, my lord, you will also refer to the earlier judgment. Para 27, page 65. It says, my lord, in the opinion of this court, the petitioner has been able to refute the contention raised by the state respondent in as much as the fact that an assertion has been made that there is no legal provision for the petitioner to set up said check gate in the case of Mayantis, my lord. This court has held that the power to make regulation for control of trading by non-tribals flows from the provision of paragraph 10 of the 6th schedule to the Constitution. It was further held that no power to appoint an officer. It was further held that the power to appoint an officer, staff, and or agent to achieve the objects of regulation is inherent and innate therein. Therefore, it cannot be said that the prima facie the petitioner has no legal jurisdiction to set up the said check gate. Now, my lord, para 29, I'll just read this. one or two more paragraphs, my lord. On the alleged violation of the provisions of the Control of So-and-so Act, this court is in agreement with the argument raised by the petitioner to say that the question of whether the check gate of the petitioner is on the national highway or beyond, it can be ascertained only when the entire matter is heard, as that is the crux of the problem in these proceedings. Prima facie, it cannot be said that the petitioner has set up the check gate on the national highway. It may also be mentioned that the highway administration ought to have raised an objection to file a complaint if such act of violation within the jurisdiction has been committed. There is no record of such complaint at this juncture. And then your lordship was pleased to grant interim order. And interestingly, my lord, this interim order is continuing till today, my lord. This was passed in 3/8/22, my lord. Is more than 2 years.
This order was a sale.
Not a sale, my lord. The main writ petition is pending, my lord. This is an interim order passed by your lordship, my lord. Now the main writ petition, whenever the matter is listed, a similar matter is pending before division bench. On that ground, the matter has not been argued. The main matter has not been argued. But the interim order is continuing. Interim order has not been assailed anywhere, my lord. So, my lord, at this stage, I am only praying for an identical, a similar stay order, my lord. And there is no reason, there is no difference between this case and the present case, my lord.
See, you are referring to the other case. This court has no record of that case.
But the order is before lordship,
except the order,
my lord.
And there is no specific description of the impugn order in this interim order. But see, what is apparent here, as Mr. Shulai has pointed out, this order was passed under section 163 of the PNSS. See, that has to be kept in mind.
My lord.
If an order is passed under certain provisions of law, and there is a remedy, there's a remedy to it.
My lord,
it is incumbent upon you,
my lord,
to pursue that course of action. Now,
my lord,
against this impugn order coming by way of a writ, whether even the maintainability has to be questioned.
my lord, what I'll just submit, my lord.
You see, it may be right, may be wrong. What you have pointed out, maybe it was passed on a wrong premise. That is not for this court to decide. But it is. You see, your first course of action should have been to assail this order in the proper forum. And if there are avenues
My lord,
to come before this court, you could.
My lord, I appreciate, my lord. But what I'll submit, my lord, lordship in 226 can definitely look at the order, my lord. Now, if the basis of order, the foundation of the order and conclusion of the order is perverse, my lord, your lordship will always interfere, my lord. My lord, the impugned order says, my lord, state government has zero tolerance.
No, see, Dr. Musga, what I understand is, if you had pursued, see, the course of action as is required, or as has been indicated in the impugn order, any further action or orders passed therein could have been subject to, a writ jurisdiction, but not at this stage.
My lord,
that is my limited understanding.
My lord, what I would submit, my lord, your lordship will look at the impugn order, my lord. Well, impugn order is not based on any ground of 163, my lord.
The impugn order is passed under 163. You say that 163 is parameteria to 144,
my lord.
Fine. So if that is the case, see, we cannot interfere with the power of the district magistrate, who is seized of the situation at the ground. Now, on such observation or report or whatever the case may be, this order has been passed. And Mr. Shulai was saying something. Where is the remedy against an order passed against
Lordship,
in
kindly
163?
come to Lordship 1 second. Just a minute, Lordship, please. Lordship, the contention that this the order will not come under the purview of 163, Your Lordship.
Anyway, this order
Lordship,
it is
that
clearly
I'll reply,
indicated.
Lordship, Lordship, kindly come to first, Lordship, kindly come to 163.3. Subsection 3, Your Lordship, it says, an order under this section may be directed to a particular individual or to person residing in a particular place or area, or to the public generally when frequenting or visiting a particular place or area. Then, Lordship, I'm taking straight away, Lordship, to subsection 5. Any magistrate may, either on his own motion or on application of any person aggrieve, resign or alter any order made under this section by himself or by any magistrate subordinate to him or by his predecessor in office. 6. The state government may either on its own motion or on the application of any person aggrieve, resign or alter any order made by it under the provision of section 4. 7, Your Lordship, when an application under subsection 5 or subsection 6
I think,
is
yes, 5, 6 and 7 will cover that.
Lordship, yes.
But my lord, I agree. The provisions are there, my lord. But my only prayer for your lordship will kindly examine the nature of order, my lord. The intent behind the order, my lord. My lord, order clearly says that this is because of zero tolerance of the state government.
True. You see,
My lord.
true. It may be so. It may be so. That would be the purport of the order. But the manner and the fashion wherein the order was passed, it was clearly under certain provisions. Where, as I'm repeating the same thing, you have the remedy. Have you preferred? You see, in the first instance, when was this order passed?
4th of February.
4 February, Your Lordship. 4
Now we are in 26.
And another aspect
Have you at least made an attempt to take recourse to this provision?
My lord, in my humble submission, the district magistrate is a functionary of state government, my lord.
Whatever the case may be, if you had done so, and any response has come, or no response has come, then you can take further from there. But not, I don't think, not at this point.
My lord, my only request would be to kindly examine the nature of order, my lord, at least. Whether this order at all is sustainable under 163, my lord. My lord, if your lordship permits, I'll again read when 163 can be invoked.
You show me a legal precedent where, under such circumstances, this writ court can take, can pass necessary orders.
Well, when 163 can be invoked, my lord.
You are harping on the nature of the order.
My lord.
When the order was passed,
My lord.
you see, I'm not saying that the order is right. For all intent and purposes, it may be wrong, but nevertheless, it has been passed. So your counter should be first to the provision that was laid down in the order, impede order. Then, as to why the order was passed, how the order was passed, it was passed mala fide or whatever, that will be looked into, but not in the writ court. Either you satisfy me on this point, or we call upon the respondents to file their counter, and matter will be heard expeditiously. If you want,
my lord, kindly give me, because I'll try to get some reason whether on the face of 163 can be invoked in this kind of situation. My lord. Friday or Monday, my lord.
of course, you see,
not Friday, Your Lordship.
you may come up. You see, you may come up with the contention that presence of an alternative remedy would not deter the writ court from taking up any matter.
Not only that, my lord.
But
My lord.
you see, but it doesn't mean unfettered.
But I'm not on that aspect, my lord. I'm on the aspect whether this order is on the face of it, my lord, when 163, the invocation of 163 was right. When the underlying idea is something different, my lord, and they give it a color of 163, when the underlying idea is something different, when the underlying idea is a zero tolerance about toll gate. Now, this honorable court holds the district council has the power.
We see, Mr. Dr. Muzika, what this court is concerned is only on the forum of redressal. Whether
I'll try to convince you.
Whether this is the forum or
my lord,
any other forum.
But I'll only try to impress upon my lordship that even order on the face of it is a mala fide order, my lord. Your lordship can. but trying to give it a different color of 163 or 144 or something, or give it a color of a FIR, my lord, when the underlying idea is something different, my lord. The lordship, in my humble submission, can definitely examine that.
As far as your bona fide is concerned, there is no objection, no complaint that you are the,
There is no complaint.
the person who has been empowered to run the check gate or whatever.
There is no dispute about that.
That power is given by the district council.
That power is, yes.
So the state government, the state here is not on that aspect. It is only with regard to the, the presence.
Whether we are creating any public nuisance, my lord.
Lordship, I'm
Now-
questioning the legal authority of the district council, your lordship, because that liberty has been given to the state, your lordship, at page 48 of the writ petition, your lordship. Because in that mountain mall, your lordship, the issue in that case was regarding the termination of a contract, your lordship. So, your lordship, I was called to address on that issue, your lordship. Then I expand the issue, your lordship, as to whether the district council has the legal authority to set up check-gate. Where is the source of power of the district council under the 6th schedule, your lordship, to set up the check-gate? So that is why that liberty has been given by the then Honorable Chief Justice, your lordship. If any question arises, then the state is at liberty to question that authority, the source of power of the district council. Right now, your lordship, we are on that also.
You can file a counter in the record.
Lordship will file a counter accordingly, your lordship. Highly apply, your lordship.
But obviously, see, except for the stated provision.
My lord, again, lordship has noticed one thing, my lord. State is again falling back. So it is very evident, my lord, 163 is only a misnomer, my lord.
Could be.
Their real idea, real intent behind issuing the order is that district council has no power, my lord.
They have taken, perhaps they have resorted to this form of an order when there was no,
No
other legal way.
No public nuisance, my lord.
Lordship,
There is no public
kindly see,
nuisance,
your
my lord.
lordship, is on the
It is
national
so
highway,
evident.
your
It is so evident, my
stopping
lord.
randomly the truckers, your lordship.
It is so evident, my lord, from even the submission of the learned AAG, my lord, that the underlying idea is something different, my lord.
I don't have any, your lordship. I'm going as per law, your lordship.
But if they have been, you see, if they have been duly authorized, proper process was followed.
That also is that source of power also is doubtful, your
Well,
lordship.
district council is under their control. They have a department of district council affairs. Why don't they issue a direct letter to district council? They stop all these gates, my lord. They will not do that, my lord, because dispensation, whenever the dispensation change, my lord,
check it, your lordship, is there.
rather than issuing a direct instruction to district council that no, we will not allow you to shut down all the check gates, they will not do that, my lord, because they want the check gates to run in some district council and they don't want it to run in some district council, my lord. That's the whole difference.
We'll study that aspect of the matter.
That is the assumption of the
My lord, lordship permits, since the state is filing affidavit, my lord, some interim production, my lord, till then.
That will amount to grant a final relief, your lordship, in my humble and respectful submission, your lordship.
No,
The other matter, the interim order is
Dr.
already
Muziga,
operating.
the hearing is not concluded as far as your prayer for interim relief is
On
concerned.
Monday, my lord.
We will continue.
On Monday.
Just satisfy this court on that. In the meantime, all the respondents are in attendance.
Lordship.
District council we have served, my lord, and
You are paying for
the state there.
State is 1 to 5, your lordship.
So issuance of notice is not necessary.
Not necessary, your lordship. I'm there. My friend also is here, your lordship.
Dr. N. Musika, and a counsel for the petitioner. Petitioner. Notices on the respondents 1 to 5 are not necessary to be issued, since such respondents have been are duly represented by Mr. N. Dishwal, Landed AAG, who has accepted notice of the same of this accepted notice on behalf of such respondent. Correct. Respondent 6, KHDC, is also represented by Mr. BJK Kanta, Learned Senior Counsel, Special Counsel, and as such, no formal notice is also required to be issued upon such respondent. On consideration of the submission made, this petition is admitted. However, the issue of maintainability is left open to the parties to agitate the same in course of hearing, in course of these proceedings. Where is your application for stay?
Well, interim prayer is the main petition.
There is no separate misapplication, Your Lordship.
I believe, you see, as far as this application is concerned for stay,
There should be an
this
application.
court has, I don't know whether it's under the rules or
No standard is followed, my lord. In case of appeal, we have to definitely file it, my lord. In case of appeal and revision.
Okay.
But in writ petition, there is no standard requirement.
Direction by this, not this court, by the full bench of this court. There should be a separate
Application for stay.
But
I
as, as Dr. Musgal said, whether it is only in appeal or
no, it should be covered
in all petitions.
in all the petition, Your Lordship. Be it a writ petition, criminal revision, criminal appeal, Lordship, a civil revision.
File it.
I think it would be,
In that case, we'll file it, my lord.
it would be proper because you see a separate order has to be passed. So if it is all jumbled up in the main petition, it becomes
Well, we will file it. So, if the matter comes on Monday, this main matter.
Not on Monday. If the matter comes on 6, Your Lordship, if they file that application for stay, Your Lordship.
6 is too long, my lord.
6, Your
We are
Lordship.
only on 26th. I can file it by tomorrow itself, my lord.
They come on 6, Your Lordship.
Mr.
Third.
As to the prayer for interim relief in this matter, the Learned Senior Counsel has submitted that the petitioner may be allowed to file, though has submitted that though a separate prayer is made in this petition for grant of interim relief. However, a separate application will be allowed to be filed in this regard, for which some time is sought for. Next.
6, 7 will not be here.
5,
On
6,
consideration,
then come on 4. Then.
on consideration of the submission made,
On 3rd or 4th, my lord.
Let it be on 4, Your Lordship. Then.
this matter is submission made. The respondents are at liberty to file their counter affidavit at the first instance. The next, on the anticipated application for interim relief to be filed by the petitioner, an advance copy may be served upon the respondent, who shall file a response to the same if so desired, and the same to be taken up for hearing on the next date fix. In the meantime, as prayed for, till the next general date, no coercive action to be taken by the state government.
Lordship, it has
As
been
far as the-
already dismantled, Your Lordship. It has already
All-
been dismantled,
all
Your Lordship.
dismantled?
Yes, the report is there, Your Lordship.
Report is
It has already been dismantled, Your Lordship. The report
Fine,
is
stop.
there, Your Lordship.
By
Obla,
then-
Your Lordship.
By then, Your Lordship, my presence is also ousted. Put in my papers. You have just requested to appear for today's session.
Not to be
Yes, off the record.
not to be spoken, Your Lordship. That is a different issue altogether.
No, but my colleague is forgetting that the entire Meghalaya is a tribal area.
But the report is only closed down, not dismantled, my lord.
No, it has been dismantled. There is
Your order says it is only closed down, my lord. My lord, kindly see.
It's going beyond the political.
It has been closed, so.
It has
Question,
been- it
question
has
of
been closed, Your Lord.
only status quo to be maintained, otherwise nothing else.
Status quo be maintained, my lord. Otherwise they'll come and dismantle now. Lord. Status quo be maintained. Status quo is in nobody's favor.
You have been ousted, so if it's status quo,
Well,
well,
at least
been closed, Your Lordship.
they'll not dismantle, my lord.
Lordship has been closed, Your Lordship. If that order of status quo, then they misinterpret, Your Lordship, then they will open, Your Lordship.
close means, you see,
It has been closed,
it
Your
has been
Lordship. There is
closed.
a report
That is your
which have
report.
been closed, Your
So if it is, if there is a status quo, it remains closed.
Yes, my lord.
And that has to be clarified, Your Lordship. Right?
Status quo as on date.
As on date.
It doesn't mean.
Then there is, in
doesn't
my
mean-
humble and respectful submission, Your Lordship, there is no need in passing that.
Yes, I think there's no
order.
need.
Well, they'll not dismantle our facilities, my lord. At least that much of observation can be.
You can
They'll
always,
come and dismantle, my lord.
if they dismantle, you can always seek for compensation. Damages will always be given to you.
Preventing from dismantling, but I don't think there should be any objection to that also, my lord.
So, status quo as on date to be maintained.
Obla, Your Lordship.
Deep
When do you have you decided on a date
on 4th,
On 4th, Your Lordship? Or
4th of March.
as agreed to by the parties? Let's this matter on 4th.
Obla, Your Lordship.
Daily list item number 1.
Please, Your Lordship. Lordship, in this matter, as far as respondent number 2 is concerned, my lord, service is complete. Affidavit of service is ready, my lord. If Lordship permits, we'll file it.
Affidavit of service?
Yes, my lord.
You have not filed.
No. We've taken steps. Service is complete, so we'll file the affidavit of service for respondent number 2, my lord. Respondent number 3, my lord, affidavit has already been filed, affidavit of service. This was filed on 22nd January, my lord.
Respondent number 3.
Yes, my lord.
There are only 2 respondents here.
Sorry, my lord. Two respondents. I apologize, my lord. For number 2, we are filing affidavit of service, my lord.
And one,
One, my lord, we are facing a slightly peculiar problem. Earlier, we had apprised, my lord, that we've taken steps. Service is complete. We had affected dusty service, my lord, on the counsel of the claimant who had appeared in the MACT, my lord. That is Mr. Chaudhary. Now, subsequently,
My lordship, I have instructed from Sri N.I. Chaudhary, my senior counsel. He was out of station, and we are not ready with the wakalat.
no, who are you?
I'm,
You are appearing for whom?
I'm appearing for respondent on behalf of N.I. Chaudhary.
number 1, my lord.
Number one.
No.
You are saying that. no,
So that's where the peculiar problem is, my lord. Because on the one hand, my lord, Mr. Chaudhary, after we gave him the copy, he said, I'll appear. Now, subsequently, he's informing us that he will not appear. We have to take steps directly on the claimant, my lord. Now, today, my friend is appearing, making a submission that they will appear. So they have to make up their mind. If they are appearing, they
File
appear.
your power.
No, we are not ready with the wakalatnama because we have the old phone numbers of the respondents. We have tried to contact him, but we did not contact yet. So,
But
fix-
he has contacted you as far as this matter is concerned. So, which means that he has received
yeah,
notice.
we have received the notice.
Okay. Oh, we'll wait.
It's complete. Very good.
Mr. as General Learner Counsel for the appellant has submitted that the notice upon the respondent number 2 has since been effected, and a affidavit of service in this regard may be allowed to be filed. Pre-allowed. As far as respondent 1 is concerned, Mr. has entered appearance on his behalf and has submitted that he may be allowed to file the power in due course within the next date fix. Accordingly, this matter after 2 weeks.
Item number 2.
May we please, Your Lordship. Lordship, I am entering appearance today for respondent number 2 in this case, Your Lordship. We will be filing our power in the course of the day, Your Lordship. Lordship, if I may pray, if 3 weeks' time can be granted to us to file the affidavit in opposition.
Affidavit in opposition?
It's an appeal matter. There's no scope for it.
You could help the appellant by filing a paper book, but affidavit in opposition may not be.
I am entering appearance today, Your Lordship.
Questions of fresh or new pleadings will not come.
Yes, Your Lordship.
So all the respondents are
On board, my lord. On board.
so we'll place
Yes, Lordship.
For hearing.
put up the matter for hearing.
Yes,
Yes, Lordship.
You are appearing for? One. And Mr. Learner Counsel has submitted that he is entering appearance on behalf of the respondent 2. Accordingly, all the respondents being noticed and have also entered appearance in this matter, Mr. S. General Learner Counsel for the appellant has submitted that this matter may be, this appeal may be posted for hearing. As prayed for, this is matter for hearing after 3 weeks.
Oblige, Your Lordship.
Item number 3.
Lordship, I have filed the affidavit of service for respondent number 2 and 3. It appears respondent number 3 is appearing today.
Lordship, I am appearing for respondent number 2, Lordship.
2?
2, good driver.
No, diverted, yes. And
And 3?
3, Your Lordship, they have been served, but I don't know whom they have appointed.
And 1?
1, Your Lordship, because of the inadequate address, it could not be served. So I have filed an application for service of notice by substitute way by publishing in the paper. Because by no source we could get the complete address. And that is why we have filed a missed case number 2 of 25.
No, he can help you. He is the driver.
Lordship, now the driver, as far as driver is concerned, I don't know whether he is still driving this vehicle.
12 years past,
truck.
Your Lordship.
So I can just get information from him whether he is still drives the car,
he might have his phone number, this or that,
or
whatever.
whether he is having any address, phone calls, etc. I'll just
Because Your Lordship, while our member MSCT order is passed for publication of the paper, so even in the trial stage, we could not.
In the trial stage.
Lordship, I have not received any notice. Driver has not received any notice, Lordship.
Come.
No, it was received.
Because I was told that.
How did it proceed? It has proceeded ex parte against the driver also.
Yes.
We have not received anything, Lordship.
That was a
I was
receipt.
told that the counsel for the insurance, who appeared, said that he or she will appear for all the three.
Notice was served, that means.
No,
Notice was served,
no,
it was
we have
within the
not
knowledge.
received any notice, Lordship.
That's why the insurance lawyer has told that he will,
See, Mr. General,
Lordship.
this is exactly the reason why. See, why this court or any court for that matter should ensure that due service is effected.
That's true, Your Lordship. That's
In
true.
whatever form or manner, because this is exactly the reason. Now, you say that before the MSCT, the matter has gone ex parte against the driver.
Driver and
Now
owner
he
both.
comes here and say, I have not been issued notice. So, he will have a course of action as far as his defense is concerned.
No, in that case, Your Lordship will see, peruse the record whether notice is served or not.
True.
And,
Of course, that has to be looked
and,
now. That has to be looked into. Those are matter of records.
Yes.
But what is submitted at the bar has also to be taken.
Lordship.
So, I'm not saying that it's the gospel truth, but if such a situation, has arisen, then
Lordship.
it's incumbent upon all concerned, particularly the court,
Lordship.
to ensure that all the parties, because you have made them parties.
I have made them party, and
So
moreover,
if you have made them
moreover,
parties,
Your
it is-
Lordship,
it is-
the
it is
insurance company,
expected that you have to, to ensure that they are
after
duly noticed.
after ensuring only, Your Lordship, the case proceeds. And Your Lordship will find that insurance company has filed an application under Section 170.
Yes, that also has to look.
And they were contesting on behalf of the owner and driver.
Yes, that defense is open to you.
Yes.
It is okay.
They were contesting.
But they may have, other grounds.
And now, before the trial court, neither the driver appeared, nor the owner appeared, nor the insurance company made any attempt to bring the driver to the witness box.
Is it a case of contributory negligence?
It's not a case of, it is a pure negligence. But
Then why have you made the insurance company?
and the learned trial court has taken a too technical view and rejected my evidence and relied upon the evidence of the police people who were hand in gloves with the owner of the truck. They have taken and initially they registered a UD case. Then I filed an application before the judicial magistrate at Nangpo, and that it requires reinvestigation by some other person because it was a case of pure negligence. One passenger was traveling with me with the deceased. He was not examined, and other eyewitnesses who were present on the scene.
We'll not go into the merits of the case now.
Now, presently, Your Lordship, position is this: we have filed one affidavit of service of respondent number 2 and 3. 2 has entered appearance, and so far 3 is concerned. I think they will come. Insurance company will appoint somebody.
They should.
In fact, they have sent it first to Sandeep. Sandeep said, "No, I cannot appear because my father is there." So it is returned. Maybe next date they will appear. But so far, respondent number 1 is concerned, Your Lordship, will find the address is only Beltola.
You in the light of what has transpired, you find out the correct address and get it received.
Lordship, we have made all attempts. Only the thing
is willing to help
that driver may be asked.
He is
that
willing to help
I am willing, Lordship, because as far as my client is concerned, he is not driving the same vehicle right now. So
anyway, that is
in that event, I'll contact with my client, and if he is able to give the phone number and address, I'll provide, Lordship.
that is there. Then,
so since the last date this matter was taken up, you have not taken fresh steps.
No, fresh steps, Your Lordship. We couldn't get any address, Your Lordship. Save and accept the address which was available, Beltola, and Beltola, when we sent it, it came back insufficient address. And the police has also not collected. Even the insurance company, insurance policy also reveals this is the address.
You are the claimant.
I am the claimant.
What is your case?
My case is this, Your Lordship, that my husband.
Why you are grief against
Order of the MACT, because MACT dismissed my claim.
Oh, dismiss your claim.
On the ground that negligence was on my part.
Okay,
Negligence was on my part. And disease has 4 children and wife, and from the last 12 years she is struggling. The case is of 12 years before.
Fine. Mr. V.K. Jindal, learned senior counsel, who has submitted that in spite of this court's order dated 11/2/2025, the correct address of the respondent number 1, public owner, could not be ascertained. The learned senior counsel has reiterated that this court may allow issuance of notice by substituted method, that is, by publication in the local newspaper, where the address of the within the area of the last known address of the respondent 1 is available. Mr. PDA learned counsel has entered appearance on behalf of respondent 2. No appearance has been made on behalf of respondent 3. On consideration of the submission made by the learned senior counsel as regard the issuance of fresh notice by substituted method as far as the respondent 1 is concerned, considering the fact that as submitted, considering the fact that the submission was made that the matter has also proceeded ex parte before the learned MACT as far as the respondent 1 is concerned. Therefore, the prayer of the learned senior counsel is allowed. Let steps be taken accordingly. Place this matter to 2 weeks.
Obliged.
Your Lordship, the driver may be asked that in case a substitute allowed.
That is unofficial. That is off the record. Right. You talk to him. He'll try to find out your phone number, this or that. Then you take your own course of action.
If I get, obviously I'll inform my senior. Obliged.
Item number 4.
Lordship, here I have filed application for amendment of the writ petition, Lordship. That means case number 27, 28 till 31, Lordship. Incorporating the
Your Lordship. This has been allowed, isn't it?
No, Lordship, because because amendment was not allowed, only implement was allowed.
Oh, implement.
Implement was allowed. Then on the previous occasion, my Lord put the query whether the petition has been amended or not. So these are the things I need to incorporate, Lordship. Unless
if you have implemented a new party,
yes, Lordship.
It is but proper for you to amend your
petition, yes, Lordship,
with relief sought for against the newly implemented.
Yes, party. that is the thing I want to put in the.
So you do that.
Yes,
it's a natural course.
You will see here in this amendment petition, character of the petition is wholly going to be changed.
Hmm?
Character of the petition, including the prayer, everything is going to be changed as a whole. Whether it will be allowed.
That you counter that in your counter affidavit.
Counter affidavit, Lordship.
So this is in this petition for
468.
That you can do.
Otherwise, Lordship, now that will...
Because Mr. Devnath, once the impleadment is allowed, as I've said just now, if the petition is not amended to allow the petitioner to state his relief sought for against the newly impleaded respondent, then the whole purpose of impleadment becomes
it will be purely as a fresh petition. So let them withdraw and file fresh one.
You can question the maintainability when the matter comes up for hearing.
Yes.
As of now, you are free to file your...
Otherwise, that will lead to multiplicity of the proceeding, Lordship. Now, one hand, if I file a fresh petition, now the two bands will hear the matter. Then there is all likelihood that prolong the
truth.
When this party is filing going for this amendment the petition, and the rule that say if that character of the case will not be changed. But
this is character of the case will not be altered, Lordship.
We'll see. We'll examine that. In due course, we'll examine. Mr. S.A. Sheikh, Learned Counsel, the petitioner has submitted that on being directed on prayer made and on being directed by this court, the how many respondents have you pleaded?
Only one, Lordship. Only one. Respondent number 6.
Fresh. Another respondent has been impleaded in these proceedings. Has been pleaded in these proceedings, for which being directed. However, since the petitioner would seek specific relief against the newly impleaded respondent, therefore the petition has to be suitably amended to accommodate.
That is para 4, Lordship. I want to incorporate para 4 in the amendment. That is the relief.
To incorporate such a prayer. To this extent, prayer is made for amendment of the writ petition. The court, on consideration of the submission made, is in agreement with the petitioner, and therefore will allow the prayer made so as to enable the petitioner to amend this instant petition. Accordingly, this instant application being kani pass out on this case kani instant application hereby disposed of. Main case by agni pursuant to this court's order in MC WPC number 27 of 2025, wherein this court has allowed the petitioner to amend this instant petition on a new respondent being duly impleaded. The amended writ petition is accordingly to be filed within the next date fixed, with advance copy to be issued upon the respondents, so as to enable such respondents to file their counter if so advised. It is a 2018 matter.
Yes, Lordship.
So I don't think we should prolong the matter. Let him file the amended petition. You file your counter, and on the next date.
Otherwise, that will lead to multiple.
So we'll give you 3 weeks time.
3 weeks.
And no adjournment.
Yes,
if you don't file a counter, we'll take it as if you have not decided to file.
I'll not.
The whole process is to be completed within 4 weeks.
My lord.
So it will whether he will file the amended.
I'll within that I'll file it.
Please, Lordship, I'm appearing for respondent number 4 and 5. We just received this case yesterday only, but we have some instruction to require.
My lord, this is the respondent number 6. I am claiming.
You are not the principal, respondent.
Yes, respondent. Yes. Now, Lordship, 4, 5, 6, 7, and 8, Lordship.
It has taken too long, you see,
Lordship,
for this matter to be decided.
4, 5, 6, 7, and 8 item number. These are connected. And 9 and 10, because we have filed only
just a moment.
In this case,
Nung tuka ong tuka you.
4 to 8.
Em katuka I direction em you petitioner to file the amended petition. Amended petition to be filed within 2 weeks from today. Counter affidavit to be filed within the next 2 weeks.
I'll file it within 2 weeks, Lordship.
And the matter to 2 weeks from today. And a counter affidavit to be filed within 2 weeks from the date of receipt of the amended petition. This matter to come up for hearing after 4 weeks.
Master.
Next.
Lordship, I beg to mention item number 15.
Fifteen.
15. 14 and 15, they are connected.
You're for?
For the respondent.
Respondent?
It's the respondent.
For the appellate, my lord. 1 week.
Okay. I'm praying for a week's time, Lordship.
Fourteen, 15 are connected matters.
Okay. On pre-made by the state respondent, by Mr. Leonard G. For the state respondent, matter not objected to by the petition appellant, but the Leonard counsel for the appellant, that is adjourned. This is save up to 2 weeks.
Highly obliged.
14 and 15.
May I please, Your Lordship? Lordship, I beg to mention item 10, Your Lordship. I pray this matter to come after 1 week, Your Lordship.
4 weeks?
Yes,
Why?
Your Lordship, my conducting senior, he's got engaged with the EC meeting, Your Lordship. So I pray 1 week's time, Your Lordship.
This matter, this is a hot matter.
Hot matter. We'll have it after 2 weeks, my lord.
On pre-made by the appellant, this is matter up to 2 weeks.
Highly obliged.
May it please His Lordship. Lordship, I beg to make a mention of item number 6, Your Lordship. Lordship, in this matter, I pray for some accommodation, Your Lordship. As the conducting counsel, Mr. A.Q. Bhoyan, Your Lordship, he has some personal difficulty, Your Lordship.
On pre-made by the appellant, matter is adjourned. Today the court will be liberal, since I also have some official engagement, not be sitting long. So take your chances.
2 weeks, Your Lordship. Much obliged, Lordship.
Lordship, this I beg to mention item number 7, 8, Lordship, and 9. The 7 and 8, Lordship, this matter can come after 2 weeks, Lordship.
These are all connected?
No, Lordship, this similar matter, because the POXO matters are this for
Not
item
connected,
not connected, Lordship.
Same
Item
counsel.
7 and 8, Lordship. Yeah, the issue of consent is involved, Lordship. So this consent, Lordship, it's pending before Supreme Court also, Lordship, this issue. So
Okay, let the matter be taken up, we will see.
after 2 weeks, Lordship, I'm
After?
putting this
2 weeks.
7 and 8. And for item number 9, Lordship, it can come after 1 week also.
See. Will on pre-made by the parties, or pre-made by the appellant, this is matter up to 3 weeks. 8, 9, this matter after
7, 8, 9.
7 and 9, 7 and 8 after 3 weeks, Lordship.
Since you say if that matter is still before the Supreme Court, and if there's any indication, then we will know.
And then item 9 after 1 week. Obliged.
9 after 2 weeks.
Obliged.
Lordship, I beg to mention item 11 and 12. My lord, I have requested my after 2 weeks, my lord.
Connected matters, my lord.
Kuduro Akajumo on pre-made by Mr. 2 weeks.
My lord, I have similar prayer for item number 16, my lord. 16. After 2 weeks, my lord.
Who's the
For the petitioner.
Nobody.
Appellant.
Kuduro 2 weeks. 2 weeks and 3 weeks. 3 weeks. Yeah. 3. 3.
My lord, I have another prayer for item number 17, my lord. Let it be some other day, my lord.
Excuse me. 3 weeks.
On daily list, item number 1.
May it please your lordship. Lordship, this is the case of a pension claim of pension, Your Lordship, as to whether the writ respondent herein will fall under the new pension scheme or under the new old pension scheme, Your Lordship. What happened, Your Lordship? These people, these writ pension respondent, they were appointed in the year 2008, 2009, Your Lordship. That is the admitted fact, Your Lordship. Under 3F, Your Lordship. They were regularized in the year 2021, Your Lordship. The new pension scheme, Your Lordship, came into effect on 1st April 2010, Your Lordship. So, Your Lordship, the case of the state is that since their respondent writ petition herein, Your Lordship, they have been regularized after the cut-off date, that is 1st April 2010, Your Lordship. They were regularized in the year 2021, Your Lordship. They are not entitled and they do not fall under the old pension scheme, Your Lordship. Rather, they fall under the new they fall under the new pension scheme, Your Lordship. So what happened, Your Lordship? But there was a mistake on the part of the government, Your Lordship, because in the order of regularization, Your Lordship, I'm taking Your Lordship to
page 78.
If Lordship kindly come to page 78. Lordship, I'm taking Your Lordship straight away to page 79, Your Lordship.
Yes.
Lordship, kindly see the regularization. Lordship is with me. The regularization is, however, subject to the following condition as stipulated by personnel A and ARB department by letter number so and so 27, Your Lordship. Yes. Lordship, this was a mistake committed by the state, Your Lordship, I admit, because that letter 27/8/2000 will not be applicable in their case, because what happened, Your Lordship, I am taking Your Lordship to that letter. Page
244. 242.
Lordship, kindly come to page 242. Lordship, I am taking Lordship to page 243.
Yes.
These are the people, Your Lordship. These are the people who have been regularized and approved by the state cabinet, Your Lordship. Lordship, the letter is very clear. I'm reading it, Your Lordship. I'm directed to refer to the subject quoted above and to say that the following ad hoc appointees, Your Lordship, that I'll place the list, Your Lordship, who are those ad hoc appointees under your department are approved by the cabinet for regularization. You are therefore requested to take necessary action to regularize the appointment through special recruitment by the Meghalaya Public Service Commission District House, maybe ensuring that also. Then, Lordship, kindly come to the next page, Your Lordship. The period, Your Lordship, the period of 3F appointment, ad hoc appointment of each incumbent would be taken into consideration for the purpose of leave, pay increment, pension, as per assisting provision provided under so and so, Your Lordship. So, Your Lordship, why I said, Your Lordship, that the state has committed a mistake while issuing that 21 letter, Your Lordship, because this letter, Your Lordship, this letter in which that 2007 regularization, Your Lordship, is wrong, Your Lordship, because Lordship, kindly Lordship, kindly come to the list of the ad hoc appointees, Your Lordship, are regularized by the state cabinet in that year, Your Lordship.
Yes.
Lordship, kindly see, these are ad hoc. All together, Your Lordship. This is a Finance Department, Your Lordship. Then Northern District Treasury, William Naka District, Tura District Treasury, Bakmara Treasury, Shillong District Treasury, Shillong South Treasury, Resubel Para, Mairang Sub Treasury, Maukorwan, then Director of Account, Shillong District, then Northern Treasury, Your Lordship. So, Your Lordship, I admit, Your Lordship, there was a mistake on the part committed by the by the department while issuing that 2021, Your Lordship. What I would submit, Your Lordship, if Lordship grant us the permission to rectify this mistake, Your Lordship. Lordship, I'm praying to this. It is wrong, Your Lordship. It is a wrong. It is a wrong.
Maybe.
A wrong, Your Lordship. It is a wrong committed by the state, by the department, Your Lordship. So we have, Lordship, we have the right to rectify that, Your Lordship. Only I'm seeking Your Lordship permission, Your Lordship, to rectify the wrong, Your Lordship. Because this 2007, Your Lordship, on the face of the record, Your Lordship, will not, it has no relevance with the case of the writ petition respondent herein, Your Lordship. It has no relevance, Your Lordship. Because, Lordship, Lordship kindly come to Lordship kindly. Lordship kindly come to page 182. 182, Your Lordship. Can you see that appendix A, Your Lordship? Appendix A, Your Lordship kindly come to clause 3.1. 3.1.
Yes.
The scheme shall be applicable to all new entrants joining state government service on regular basis against sanctioned vacant posts on or after 1st April 2010. It shall also be applicable to all government employees whose services will be regularized against regular posts on after 1/4/2010 with the benefit of prospective date. So, Lordship, this clause is very clear, Your Lordship. The admitted fact, Your Lordship, the writ petitioner respondent herein, they were regularized, Your Lordship, and approved by the state government in the year 2021, Your Lordship. So they will come within the purview of this new pension scheme, Your Lordship, not under the old pension scheme. Just because a mistake has been committed by the department, Your Lordship, while issuing the order of regularization, quoting, Your Lordship, that 2007 letter which has no relevance with the case of the writ petition respondent herein, Your Lordship. So my humble and respectful submission, Your Lordship, since we have the power to issue, we also have the power to rectify, Your Lordship, if a mistake is detected, Your Lordship. Only I'm seeking Your Lordship permission, Your Lordship.
I think my colleague is asking the impossible. There are so many judgments of similar nature passed by this honorable court. There is a case of Aplin Mary Sun and others versus State of Meghalaya on the same point of.
Same Lordship, we have detected now, Your Lordship.
Not detected now.
It was
Lordship,
a big
this was
mistake.
the same query asked by the honorable single judge to the Government Council. In so far this 2007 notification, they asked for instruction, came back, they said there's nothing that we can do. It is on that point, if Your Honor will read the entire judgment of the single judge, will notice that it has relied on this 2007 notification, wherein pension also was granted. Now it is too late in the day to come and say that it is a case filed by me. I'm the writ petitioner. They have come against the order of the honorable single judge. It's too late in the day to come with such a plea, Your Lordship. Now, Your Lordship, in fact, today it was fixed for. He was supposed to seek instruction on this 2007.
Yes, I have the instruction. I have added the instruction before your Lordship. If you want, you can have this.
And Your Lordship, and they were supposed. He said he will withdraw the.
No.
If that's 2007.
He
He said that.
Yeah.
He says he may.
Pardon?
He says that he may. If the situation
if this
warrants.
2007.
If the situation demand, but Lordship, can you see the 2007?
Your Lordship will have a full hearing on this because today.
No. You people, when you did answer it, no, you have not taken serious in sectional matter.
Yes, we'll hear out the appeal.
Lordship, Lordship, I am grateful, Your Lordship.
So when
I want a short date, Your Lordship. Maybe just a week's time.
On 11, Your Lordship.
Let's see, huh?
11-3, Your Lordship.
11-3 this.
Oh, Lordship will not sit on then on 12, Your Lordship.
Which one? Number. Country. Karkandai.
Yeah. Yeah.
Pixel 19.
Pardon, Your Lordship.
On 19th.
19, Lordship.
19.
Heard Mr. Initial Leonard AG, who has submitted that on instructions received. The state appellant will press with this appeal. Accordingly, matter is now posted for final hearing on 19th.
Apply, Your Lordship.
Item number 2.
It's for paper book, Lordship. It's ready. Filing today.
Mr. Nupul, counsel for the appellant, has submitted that the paper book is ready and is presented in court today. Copy of which has been received by the state respondent. Accordingly, matter is now posted for hearing. Let's see after 3 weeks.
After 3 weeks, Your Lordship.
Because you see, the board is almost
Lordship.
full.
I need to go through also, Your Lordship.
See, sometime if you keep 16, 17 matters in the hearing column, rest assured, only if parties are serious, 1 or 2 matters will be taken up.
Lordship.
The rest you just have to sleep in your chair.
Obliged.
Yes.
Apply, Your Lordship.
Item number 3.
May we please, Your Lordship. Your Lordship, the paper books are ready. We'll be filing it before the registry today, Your Lordship.
Mr. Counsel for the appellant has submitted that the paper book is ready. However, the same may be allowed to be filed in course of the day. Accordingly, let the paperwork be filed with copies to the state respondent. Matter will now be posted for hearing. List is after 3 weeks.
All right, Your Lordship. The paperwork's ready.
May I please, Lordship?
Item 4.
Maybe tag, Your Lordship, because it arises out of the same judgment, Your Lordship.
3 and 4, same.
No, for 3 we are appearing, for 4.
I may bring for item number 1.
As you file your paper book.
Lordship, I pray 2 more weeks time, Lordship.
Same judgment.
3, 4, Your Lordship. These
They're
are
connected, Your Lordship.
connected, Your Lordship.
Same.
Out of the same judgment, Your Lordship.
Out of the same judgment.
You file it within 1 week. So the matter can be heard, along with the other case. Mr. Counsel for the appellant has sought for some more time to file a paper book. Accordingly, let the paper book be filed within
10 days, Your Lordship. Maybe 10 days.
10 days. This is matter.
After 10 days.
This is matter on 19th.
18, Your Lordship. But Lordship is this bench is
19.
19, Lordship.
Item number 5.
Yes, where's the petitioner? Delay. Not yet received. The registries, the office record would show that the notice issued from the respondent 3, 4 and 5 have not been, is not yet affected. Accordingly, that the service report be awaited. This is not up to 2 weeks.
Item number 13.
Minute, please, Your Worship. Give me the review application.
Mr. Sen,
Lordship.
if I recall correctly, you say that this matter has been heard.
No, my lord, what happened, Your Lordships? This matter was heard sometimes, my lord, in the last part of, sometime in August or September of last year. So thereafter, my lord, as required by Your Lordships, some kind of return synapse is also filed. But because of the long lapse of time, on last occasion, Lordship also agreed that it requires a re-hearing. And that's how it is posted today. So, my lord, I am ready, my lord. I will always say, my lord, since my lord, long time has elapsed. And normally, my lord, 6 months, after 6 months, it needs to be reheard. So, if Your Lordship pardon me, I am ready today.
My lord, for that matter, on the other occasion when the matter was listed before this honorable court, my lord, there was a categorical submission from both sides that the matter is already heard, my lord.
I never see that.
No, heard, yes, but
heard, and we had filed written submission.
The court would say that it has to be refreshed.
Normally, Your Lordship, that 6 months period, my lord, what happens has to be heard. And there is nothing wrong. Your Lordship hears me.
I vaguely recall, yes. You are aggrieved with only that, I think.
No, that is, there is a, my lord, there is some issue regarding to entitlement of some increments, where EGC rules has been applied. Now, my lord, the learned single judge has dismissed my writ petition, my lord. Mainly, there were many adverse comments, but on the ground of delay.
Delay and latches.
That the increment, my lord, upgradation was done sometime in 2013, and I approached the court in 22. So, the learned court says there is a long delay. But my contention before the learned single judge was that my representations were pending, and this representation was answered in 2020. 2020, government has taken a stand. I will say, my lord, the government, because the Director of Higher and Technical Education, which is my employer, they said, yes, you are entitled. And they have directed, my lord, the Education Department to do the needful. Nothing was done. 21, within a reasonable time, a copy was given to us. 21, we filed a representation. We said, please release it. Nothing happened. 22, we filed a writ petition. But the learned single judge, my lord, without a reference to my representation, only on reference to my lord 2020, dismissed the writ petition. So the grounds taken before the appellate court, my lord, my main contention, only on the delay, there is no delay. Because 2020, it was answered by the government. And 21, there was a representation. So there is no delay. Now, learned single judge, my lord, when the appeal was called, one of my lord was in the bench. I was not there. Somehow it happened. And now my lord decided, and it was dismissed only on the ground of the appeal. Now, while deciding the ground of appeal, your lord, delay, somehow, my lord, it escaped the notice altogether of 20. There is not a remote reference of that 2020. Because delay I can negotiate only with that letter of 2020. There is no reference either directly or indirectly of 2020 and my representation of 2021. So that is a relevant consideration. My submission is, That is a relevant consideration before the appellate court to deciding the delay to take into consideration. So that somehow escaped the notice. Now, what is the law of review, my lord? It should not be, my lord, intricating arguments, long arguments and reinterpretation of statute, not really. It should be self-evident. If I take my lord, this is only 4-page judgment, my lord. 2 pages are excerpt from the single judge and just 1.5 page, my lord, the findings. Now, there is no remote reference of that letter. So, my grievance is here. These should have been taken into consideration because this is a relevant consideration. Now, what is a relevant consideration, my lord? I have referred to this letter.
But as far as the letter is concerned, that has been urged before the
single judge. So that was not even remotely referred. And all my grounds I have taken, mainly my grounds, there is no delay. This letter is there, followed by a representation in 21. Now, while the appellate court deciding my appeal, totally, my lord, it's not the question even remotely referred to that. It has, my lord, what happened? It has escaped the notice. Somehow that day I was also not there. So this becomes a ground for review. Now, what is the ground? The decision also I have referred to the Supreme Court decision. It should be self-evident. My lord, look into it.
So, see, Mr. Sen, those facts you have.
I have said.
You have reduced them in your written
synopsis. I have given.
You have also done the same thing.
Yeah, I have given everything.
My lord, for that matter, my senior is going into the writ petition, going into the writ appeal.
Well,
and all this matter is already, my lord, this matter was already taken up by this honorable court. Now, if my senior is aggrieved with the, my lord, findings of the learned division bench, my lord, in the writ appeal, my lord, whether review can be filed, he has to move forward, my lord. Review is not the ground. Whether any ground for review is made out in this case, my lord, my respectful submission is no ground is made out.
That would be your style.
Yes.
It would be, see, now it would be upon this court to look into the contention of the parties and to see if any review is called for or not.
Because, my lord, even the decision of this honorable division bench, my lord, all the records have been thoroughly gone into by this honorable court, my lord. It is not that none of the parties made elaborate submission,
That's why, my lord, what I am saying, my lord, not what I am saying, I am not finished, my lord. I am the review petitioner.
Lord,
What I am saying, that's why it needs a. That's why it needs the
I have
hearing.
objection because
why it needs the hearing?
No,
as a review. My duty is to what, your lordship, to place before the court, my lord. There is a ground of review.
I have serious objection, my lord.
It is very
because
narrow.
he is going into the narrating.
My lord, I don't know, but is it my case? Shall I make my submission or he will make submission?
Because review, he have to
I make a
ground
submission.
for
You
review,
point
my lord.
out that I have gone
He is
beyond
going into the facts of the
merits.
petition, my lord.
Now you see. Now you tell me. You tell me. Since both sides have filed their written argument,
my lord,
would it be sufficient for the court to just go through that?
I don't think, my lord, because
My
long lapse
respectful
of time, my lord, I need to, my lord, refresh lordship. Had it been, my lord, 6 months and all, my lord, would have been all right.
We'll take up the hearing on. You fix a date.
Lordship, in fact, my lord, on my prayer, your lordship, I don't know, last occasion also
Yes,
I made a
exactly.
prayer.
But
Lordship, it was
today I don't think
some inconvenience.
I have an official meeting to attend.
But only it's all right, your lordship.
No,
only thing, my lord.
We'll do it.
If you can avoid, my lord.
We'll do it next week.
No, my lord, that is the problem. I have some personal difficulties next week. If your lordship can post it any day after 12.
Abun. This matter should not be,
It's a long time. Only thing, my lord, I will
26,
26. All right, lordship. Only thing, my prayer, your lordship, my lord, that issue should not reopen. It should settle, my lord. I need to refresh your lordship minds. I know, my lord, there is a very narrow ground for review. Lordship will permit me, my lord, take my lords to those points, urge those points. Thereafter, what my learned friend, I cannot, you want to shut me out. That should not be. He will point out that there is no ground for review. This is for the court for taking a decision.
We'll hear you. We'll hear you. Matter has been admitted. We'll hear the parties.
Exactly, my lord.
We'll
will see whether I am urging a ground for review which is come within the ambit of review. If not, Lordship will dismiss.
We'll hear you to your heart's satisfaction.
Well,
I will pass the order. Rightly or wrongly, that is for you to decide.
Lordship will hear the matter.
My respectful
Same to
submission.
you.
No, because again he will come. Last time also he came that we
Yeah,
have
my lord,
filed,
because-
everything concluded. He is reopening
My lord,
and I will not
my lord,
reopen, my
in
lord.
the
I'll have to
review,
please.
my lord,
Again he is saying same thing again. We'll say the next
my lord,
day.
the very start of the submission, my lord will kindly observe. He started from the submission of the writ petition. The whole base of the case started from the writ petition.
It will start from writ petition. Where else it will
It's a
start?
review. First, you have, my lord, my learned senior should lay the grounds for which the review is made.
Who will submit first, my lord? I'll submit or he'll submit. I don't know. I am the review petitioner, my lord. I think I have the privilege to make my submission. If my submission is not all right, my lord, it's totally wrong. I am relying on certain facts, my lord. You should not have.
That's
It is
going
for
into the
him to
facts of the case,
controvert.
my lord, then he is
But
opening up the whole even
where
writ
we
appeal,
have
my
not
lord.
even made a submission. How is saying I am opening up?
We know the parameters to be considered.
Exactly. It's very narrow, my lord.
We will see.
It has to be self-evident, your lordship. The laws has been recently again reiterated by Supreme Court. I know that much. So, my lord, only thing next date of hearing again, my lord, that we have filed the hearing, it should not go on. My lord, that should not happen. So every time it will happen,
This
and
kind
we
of,
should
my
not,
lord,
we should not create
I have strong
confusion in the
objection
court.
to this.
No, we should not create confusion in the court.
No adjournment.
I have a right.
No, my lord, I have
I'll
not
my
adjourned
privilege. I'll make my submission, my lord. Of course, up to him. If I am making a wrong submission, if I am misleading, it's duty to point out, my lord. And it is ultimately my lord will take a call.
On premier by the parties, this is matter for the hearing.
This is for hearing, my lord. Not you will kindly mention. This is for
Yes,
hearing.
it is for hearing.
That's what I said. This is matter for the hearing on 26.
26, my lord.
All right.
Item number 18.
May I please, Your Lordship? Your Lordship, this is appeal against conviction wherein the trial court convicted the accused. Yes, 18.
Lordship, here.
Your Lordship, this is today fixed for application on plea of juvenility. I have raised the plea before this honorable court that I was, yes, Your Lordship. On 17 also this matter came up, but Mr. Sir Khalid, he took time, so as such.
But he is not available today also, my lord. So if this matter can be listed after,
Your Lordship,
I will inform him, my lord.
Your Lordship, I got to know that Mr. Gurung is the conducting counsel. Just now he said to me. May I start, Your Lordship? Your Lordship, I filed one miss case here, miss case 93 of 2024.